Members, please take your seat. Next, Dr. Chang. Oh, sorry, Mr. Jeremy Tam, speaking for the first time. Thank you. I was at another meeting, so if my question's been asked, Chairman, please let me know. Now, I heard the discussion about limited registration. Just now, the Medical Council say it a lot, but what about the administration's response? Have I got it right? Now, for limited registration, the Medical Council has very objective conditions. Apart from a few disciplines, and the candidate must be able to communicate in Cantonese, there must be a specialist qualification, and also there must be the need. So, is my understanding correct? The Medical Council has this requirements, but the Hong Kong U and Chinese U do not have similar conditions. Is that right? Mr. Sun? Thank you, Mr. Chairman. Mr. Tam. The hospital authority has to engage doctors with limited registration coming to Hong Kong to address the shortage. They have three requirements. First, equivalent to the intermediate exams of the Hong Kong Academy of Medicine, 3 years or more of experience working in hospital, and fluent English and Cantonese. Those are the requirements of the hospital authority. The two universities have not set such requirements as the hospital authority. But as we explained in the paper last time in detail, for the two universities, if they want to hire doctors with limited registration, there is a stringent process to follow. In the paper last time, we explained that initiation process, the monitoring process, and the recruitment process. Now, for the two universities, they want to hire doctors with limited registration to do teaching and research work. They really take it very seriously. Okay, thank you. So you mean the two universities have stringent requirements? Is the case that the requirements cover the three conditions mentioned for the Medical Council or not? Are they two different mechanisms? Yes, they are two different mechanisms. So hospital authority, they want to hire frontline medical officers. So they have laid down three additional conditions. But for universities, they have regarded their own needs. They have their own mechanism. And it's hard for them to say there is a uniform requirements for so many years of experience. So they hire people that meet their needs, rather. Well, so that you know a bit more. For hospital authority, they hire only frontline doctors. They need to meet with patients, and because most patients speak Cantonese, that's why they have the requirement. But for the two universities, seeing patients frontline is not the primary duty of these personnel. They do mostly teaching and research. That's why the requirement for fluency in Cantonese is different than that for hospital authority. Thank you, Mr. Chairman. But still, I don't see the logic. Because for the two universities, if they hire doctors with limited registration, there's still a chance that they may come into contact with general patients, because it's said that they are allowed to see some patients up to a certain percentage. So that means for patients, they will still have the same problem. Or are you going to say that, okay, like the airport authority or hospital authority, they hire part-time staff, and then the number of frontline patients they meet will be the same as that for the two universities. That's why they don't need the three requirements. I don't think the hospital authority would do that, because if we look at it from the point of view of patients, they might think, how come when I go and see a doctor with limited registration at the hospital authority, it seems at least, there are these three additional conditions, but they don't have these conditions at the two universities. Now, if you extend the registration period from 1 year to 3 years, and since you're making this change to the legislation, why don't you include these requirements of the hospital authority in the bill? So, and there will be a standardized, that will be the same set of standards. If you ask me personally, Actually, some other colleagues also asked whether the hospital authority is being too strict. If you ask people to speak Cantonese, who will come? And just now, Professor Lau told us they want to hire people of a world caliber to come to Hong Kong to teach. If you add the requirement of Cantonese, maybe universities can't hire any professors to teach, not to talk about meeting patients. So you mean for the say for the hospital authority and the 2 universities? Now, because the limited registration is to be extended to 3 years, then for the 2 groups, they should have the same recruitment condition. At the end, then both would not hire the people they need. In that case, just take out the Cantonese fluency requirement, because here we're talking about professional qualifications. But professional qualifications are just not the same as the language requirement. That's why I mean take out the language requirement, because the hospital authority has this language requirement, so take it out. And so for the 2 universities, they also follow the other 2 conditions. That it means 3 years of experience and specialist qualification or professional qualification. Then we could address the point of the chairman if it's just about the language issue. Professor Lau and Dr. Zhou have raised their hands. I think the question is, under the law, the medical council has the duty to ensure the safety of patients. That is, people must meet minimum qualifications before they could be granted limited registration. So universities, when they want to hire professors, they have their own considerations who they want to hire, and hospital authority, they have their own considerations. Department of Health, they also have their own considerations. But if these considerations are different than the requirements of the medical council, the medical council would only just look at professional qualifications. Dr. Zhou. Well, it's the English term phrase "mind your own business." What kind of people the hospital authority or the universities hire? There's nothing to do with the medical council. It's for the dean, the department head of the university to decide what sort of people they need to hire. And our duty is only to ensure the safety of patients. And so we lay down the minimum requirements in the law. And anything in addition to that, that's not covered by the law. But if we want to include that in the law, there's a danger that we may undermine the autonomy of universities. No, I don't quite agree. It's not whether it's dangerous or not. Now, because for hospital authority, their target is frontline patients. If we just say take out the language requirement, and then you apply the same conditions to universities, let's say for people coming to teach at universities or for academic exchange, and they have contact with patients, then in theory or in principle, probably they have more experience or more senior than someone who take care of frontline patients at the hospital authority. So it's not possible that it's more dangerous. Now, you're right. For the medical council, it depends on what powers are given to you under the law. Here, we're just talking about applying this condition to doctors with limited registration. I don't see why there's a danger. No, it's not that he said there's a danger as such. It's just that if we want to regulate who the universities could hire to do teaching research, then it may undermine the academic autonomy of the universities. But then the conditions are already there. The medical council lists out these conditions, so they are already there. And the universities cannot hire people who do not meet those conditions. We're just saying that you add 2 more conditions that are now applied by the hospital authority. That's all. Let's take out the Cantonese requirement. That's it. I don't see why there's a problem, unless you say that for people you hire, they cannot really meet the requirements of doctors who treat frontline patients at the hospital authority. They won't even meet that requirement unless it's the case, but it doesn't make sense.
Dr. Zhang, we have a standing practice in that with overseas credentials or registration, those are basic requirements for the doctors. On top of that, you can require anything else you like. But we should see whether there is such a need. If you feel that the current standards are inadequate, there would be a reason for further extending the period of registration. So what was the basis of extending the period to 3 years by the HA? That is the decision of the HA. All along, these are the minimum requirements. DHA and universities and Department of Health all have their own requirements. So it depends on why they require doctors with limited registration. They must ensure that these minimums are met. And specific departments could set higher requirements if they want. Please go on, but I just feel what you said has been repeated by different members. All right. I don't see the relationship or consistency. If you feel that some universities should hire doctors with high credentials, that's not what he said. He just said that universities would hire doctors with limited registration, and they would have multiple functions, including teaching and research, etc. I'll wait for the next round. Dr. Cheng Shung Tai, second round. Dr. Cheng is not here. Mr. Yip Kin Yun, second round. I have a few questions on limited registration. Dr. Cheng just talked about doctors with limited registration, and he felt that they are no different to ordinary doctors. If we have doctors with time-limited registration, if any issues arise over the course of practice, after a specific time frame, they might no longer be licensed, and if we are to follow up on their issues, but given that they might not have a license anymore, what can we do? And will we face higher risks when we face these issues? Dr. Chang also talked about different scenarios for these doctors with limited registration, for example, those hired by the HA or by the two universities. And for the news article I mentioned, it's apparently applied to an independent medical practitioner. We have touched upon this issue multiple times, but Mr. Sun, please repeat it. For the first question, Mr. Yip talked about the current arrangement of giving a one-year limited registration, and for doctors, their registration is very important. For 3-year registration, they would pay even more attention to what they are doing. I think the Medical Council can better exercise its powers. And as I said, there are many types of notices under limited registration, there's more focus on notice number 2 on doctors hired by HA and the 2 universities, but there are other notices. They also cover recognized doctors who came from the mainland. You cannot expect them to secure qualifications equivalent to the intermediate exam by the Academy of Medicine. We have seen such cases. And there might be different requirements on overseas doctors. So you can see that the minimums set by the law are only the bare minimum. But those are not statutory requirements. Those were drawn up by the organizations themselves. So there is some flexibility. Mr. Yu Kin Yun. Chairman. I cannot quite agree with Mr. Sun. If I have a doctor's license, as you know, it's very hard to get one. If I hold the license for 10 years, I will really treasure it. If I'm told that my license will lapse tomorrow, I won't have much opportunity to think about it. So in terms of the importance to individuals, the different licenses would differ. For licensed doctors, over the course of practice, we have seen cases in which patients passed away. Their deaths might be related to surgery. Subsequently, the doctors involved left Hong Kong. In these cases, how could we investigate and follow up? If we have no clear answer, we would be exposed to a higher risk. I think such issue must be dealt with. You cannot simply say that doctors would treasure their registration and there won't be problems. I will try to help you out because they already answered the question before. They can investigate any medical incident and investigate any wrongdoings by doctors, and if there are any wrongdoings, there would be punishments. If the patient feels aggrieved due to a medical blunder and subsequently they suffer losses, and even if they get away with the preliminary investigation committee, the patients can still pursue the cases via civil means. And with a 3-year registration, I feel that the doctors might cherish their licenses even better. It's a matter of opinion. And we believe that doctors would take care not to commit mistakes because they would suffer as well. By extending the maximum period of registration to 3 years, we might see more applicants from the mainland in order to tackle our imminent needs. And various members have asked similar things, and they have all been answered. So I wonder if you like my answer. You have been very meticulous, but I think the short answer is we can resort to civil means if we are to pursue the complaints. So you told us about how to manage the risks if we go down the civil route. This is beyond the capability of MCHK. For doctors with limited registration, are they allowed to practice alone by opening a clinic, etc.? Mr. Sun, it depends on the promulgation. For promulgation number 2, an employee is needed, but for promulgations 3 and 4, they were possible because they were doctors who had practiced in Hong Kong before 1964. Today, we are talking about the extension of the limited registration from 1 year to 3. And for doctors hired by the Department of Health and the 2 universities, they should not be allowed to practice outside. And they would secure a license, and they would be allowed to practice outside without a license. We will extend the period from no more than 1 year to no more than 3 years. Would all the doctors mentioned in promulgation 4 be covered? We are just talking about the maximum, so the MCHK can decide what to do. All cases of registration under the promulgation would apply. For the proposed extension, the government hopes to achieve something. Some specialist doctors visiting Hong Kong could contribute, and we hope to launch this 3-year program to help them. 1 year is too short. For promulgation 3 and 4, the system would not be useful. So we are actually relaxing the renewal requirements for doctors. So how can we strike a balance? Barring any major issues, I wonder why we won't further extend the registration period. If we resort to limited registration, well, there was a reason for doing it. Do those reasons still apply as we extend the period of registration to 3 years? When we deal with doctors involved, are we giving consistent treatment? I think the Medical Council could decide that. The MCHA is required to follow certain rules. The maximum period should be 3 years, and based on the scenario, the Medical Council can draw up different limits. So in terms of government policy, if we allow people to stay more than 3 years, that could be a factor or appeal. But some people feel that 3 years might be too long. So there is a deadline by the government, and we would consider whether further relaxations are warranted in the future or next time. Next, Dr. Chen Xiong Tai, second round. Thank you. The MCHK talked about the improvement to the complaint investigation and disciplinary inquiry mechanism. Currently, a legal advisor might be appointed by MCHK to take care of statutory duties, and in the future, the SOJ may appoint any counsel or solicitor in private practice to carry out the statutory duties of the Secretary. When you talk about counsel or solicitor in private practice, do you refer to counsel or solicitors who are already in practice, or those who are qualified to practice? So that is a point of contention. Since disciplinary inquiries are rather long, they may take 2 or 3 years. So if legal officers are employed, there would be less conflicts. But if counsel and solicitor in private practice are allowed, how can you prevent conflicts of interest? This is something you should clarify in the bill. Mr. Sun, thank you very much. And according to the law, people who are qualified to practice as counsel or solicitor could be employed by the Secretary for Justice. And the challenge is that even if there aren't enough legal officers to support the handling of the case, they will still a very long time. This is not limited to the medical council. And under the medical registration ordinance, it's very inflexible. So our proposed change merely serves to add flexibility. So in other words, even counsel or solicitors who are qualified to practice might be invited. Well, with the minimum requirements, there might be other requirements, such as handling of issues relating to the doctor's experience, etc. So according to law, they can do it, but in a pragmatic sense, they have to see whether there's some conflict of interest. But this is something we cannot write in the law. In terms of qualification and the criteria, they are not very clear at the moment. An inquiry might take 2 or 3 years, and we are talking about counsel or solicitor in private practice. The relevant law firms and the counsel or solicitors might be representing patients and their families. The conflicts of interest will be a very sensitive issue. So the government must have relevant discussions. This would be unreasonable. I think we are trying to see whether there would be issues if we go from 1 year to 3 years. Even with 1 year of limited registration, there are still issues. I found it very hard to assign lawyers to patients. So for solicitor or counsel in private practice, if I'm on legal aid, it might be easier for me to secure someone. I tried to find one a few months ago. Even Mr. Chen Kim-po from the insurance sector did not believe what I said. So in terms of transfer of interest or conflicts of interest, they cannot secure retainer contracts from certain doctors and acts against their interests. I'm not saying that they are irrelevant, because we are now talking about extending the period from 1 year to 3. These problems already exist, even if the maximum period is 1 year.
The question is that there are used to be Department of Justice. Now that we can hire someone from private practice, so we need to. So what do you mean by for those in private firms? So for the PIC or the secretary appointed by the DOJ, and now that we propose that we could hire outside legal practitioners, I'm worried about that they're not able to find anyone from the private practice, or even if they're actually engaged in one way or the other, because the PIC would not pay that well. Ultimately, some sort of honorarium, but well, there's not going to be much, I guess. So they need to make a declaration that suppose that their own firm is handling a lot, or even one defending a lawyer, or helping with a patient, they might not willing to be nominated to the PIC. So you probably shouldn't worry too much. Or maybe Dr. Cheng, what are your views on this? The conflict interest exists since exists for a long time. The union to declare it, and the lawyers know more than us. So we offer the flexibility so that in case the PIC would have more lawyers available. However, whether we can identify them is another matter. It depends on the honorarium offered. If you ask me, if I were a lawyer, it is not. I don't have good business, or maybe I do work for PIC and look at the cases, and I would go help the patients to the litigation because I have such experience. However, you do not add more manpower to PIC. How do they have a few more? Because currently a backlog of 78 years. We have a lot of patients coming up to say that for any medical incident it took 7 or 8 years and it still have been wrapped up. That's because we need more legal advisor. So for the part-timers, about 5 million a year. You talk about the legal advisor. Can you ask the secretary, Mr. Siu, how much is your legal advisor paid? Ms. Lai? Because you know the answer. Currently, our legal advisor, the upper limit is about 2.8 million. It shouldn't be. Actually, rather 0.28 million per month. Just one advisor. Those Dr. Lee have said legal officers represent the secretariat. Currently, we're using government lawyers, and the ordinance would propose a flexibility in hiring those in private practice in place of DOJ lawyers to attend hearings, attend inquiries. Were they charged by the hour? Like Mr. Sun has said, the data would be decided by DOJ, maybe the setting of a price. Let's say the same as for provisional judges. They could come to listen in the cases. I don't know what are they called. This district court cases in which they would be paid by the hour. Would that? And Dr. K.K. Kwok, the third round of question. I have a question with Mr. Sun. I would like to know the government views on the following. In the government, or the Food and Health Bureau initiated the amendment, and there was a disagreement on views on protecting the patients. I agree. And for the limited practice, that the HA had more stringent overseas mechanism. However, I would like to obtain some figures from the government that over the past few years, and those limited registration doctors hired by universities, and the complaints arisen from them, and those the claims are made to the medical council made with them. Since they are with limited registration, they would not need to stay in Hong Kong to face disciplinary inquiry or be penalized. In protecting the public health or public interest, we need a clear guidelines. If the society don't move forward and instead to adopt the past practice, instead we don't need to amend the medical registration bill. So let's say we have more registration, more protection for one, but not necessarily for those hired by universities, because they would take care of themselves. I don't think the society would accept this. No one would afford a clear responsibility. That would be the job of the government. I've asked universities, is there any guidelines in place? But they replied they have none and not necessary, and they don't need it. So the minimums would be fine. If the minimums would suffice, then there will be, we don't need to discuss. We don't need the Bills Committee or the Medical Council to go through this bill. So when consider extending the registration, have you considered that those referred to by the two universities, would you have any standards that would safeguard the interests of patients? I think this is important. That's for Mr. Sun. Of course, and for those figures on for this limited registration, and in terms of their credentials, if available, I would like to take a look at them. And I see for documents, most of them, on page 5 of the document, most of them are junior doctors, including those under training or a short-term time medical exchange or clinical training and so on. And these are where these complaints come from, the more junior level. The complaints are not from the professors and so forth. And this is the lower level complaints that cannot make this Bills Committee rest assured. Would you take this opportunity to issue guidelines so that those doctors with limited registration so that they could do more in safeguarding public health? They are different from other doctors because the lady would need to face discipline inquiry and have a high price to pay. And for these overseas doctors in training, you couldn't catch them, and you would have nowhere to hold them accountable afterwards. And university is not able to offer any assurances. Thank you, Mr. Chairman, and thank you, Mr. Kwok. Currently, the medical registration ordinance, the medical council had the responsibility of safeguarding public health. This is a basic safety requirement. In the last submission, we explained the university's in place mechanism to ensure that the doctors' limited registration required to comply with their standards. As for and how to hire them, it would depend on the academic autonomy of the autonomy. It's hard for the government to specify all the kind of the bar to be set. The HA setting the bar which depends on the own actual needs, and you can see the universities and when hiring the professors of the most senior grade, and for those for the exchange or training. So it comes with different types. As for what the actual requirements. I feel that this falls within the academic autonomy. And regardless, besides the academic autonomy, they have to ensure safety and satisfied the medical council's requirements. As you can see that both universities are quite concerned. And in the meeting in July, the CUHK has a representative here. I recalled that that person tried to address the members' concern, and for those hired for limited registration for research and the work. And so you can supply the figures after the meeting. Maybe Mr. Soon can need to contact the medical council and the universities for this. I would follow on the second point. So respect the autonomy of the tertiary institution, which, however, it is more than that. It had to do with clinical work. So you come here to give lectures, for instruction or research, and so on. That falls within the purview of the autonomous academic policy. What we're most concerned is that they need to deal with patients. They are given the same right as the other with doctor with full registration in performing the same procedure. So if we don't deal with patients, it had nothing to do with autonomy, but then once they deal with patients, we have a lot of considerations. Actually, I actually don't object extending it to less than 3 years. So in changing that to attract or to retain junior doctors in hospital authority, that I won't dispute that. We have clear guidelines, and we accept that. So because protecting the patients is paramount, we talk about the extension applied to all sorts of doctors with limited registration. And on this point, we feel that we more safeguards. So if the two universities can provide some objective facts to assure us that would accept how we don't have any at present, and then you claim that they would do their own thing accordingly. So whatever happened to the complaints we see in the media, these are actual cases coming for our help. And now that we're to look for the doctor, he already returned to the mainland. I have no idea how to get him returned to Hong Kong, as he is unlikely to return. I don't know. However, on the hand, these are the cases we come across. To make this, it's important to have this bill to protect the patient's health. However, you came to give up on that and let the university do their own thing. Able to achieve that, where do these complaints come from? We don't fabricate them. These are actual cases. I think Mr. Xu is aware of that. So it's actually the same kind of problem that occur even for under 1 year registration. Do you think it would deteriorate if it under 3 years, so the medical council cannot protect the public? Thank you, Chairman, for asking a question. Is that when reviewing this, we hope for additional safeguards for patients, unless the Chairman said, "Oh, this is not important." I never said that. And you don't need to say that the public needed to be protected. I'm also a member of the public. I hope the medical council can protect me as well, so that your colleague, Mr. Chairman, I think the medical council and universities are quite concerned for those doctors with limited registration, or those that hope that have the competence or the qualifications. And the ordinance had explained that the medical council need to ensure that each applicant had the competence to practice medicine in Hong Kong under limited registration. And all along that the ordinance think that he conferred powers to the medical council. However, above that legal requirement, each organization have their own additional requirements, that we should offer flexibility to each organization to set out. So this is the point of contention. I believe that the Medical Council played the role of a gatekeeper, and the Medical Council had never said that because we proposed relaxing to 3 years, there would be any changes accordingly. So the same yardstick would still apply. Mr. Michael Tian. Thank you, Chairman. For this bill, I have other concern, but I want to bring it up here. This is exactly one of the focus point at the July 20th meeting. Is that the government think that having more limited registration doctors, the HA requirements are higher than those of the two universities. The two universities never require them to qualify for the intermediate exam, whereas HA does require the doctors to need to reach the intermediate exam equivalent. Because the two universities have differing requirements, so there's no direct comparison. And in the supplementary document, it claims that these non-local doctors limited registration are having to have clinical work. As you explained, so, on the question of the need for professional autonomy, I have a lot of discussion for those in the medical sector. The direction claims that it's very difficult to have a direct comparison due to different in job scope, and you need to trust the university won't just simply let anyone in, because the medical council would need to vet the applications. However, the reaction from the trade that the university is hiring this limited registration doctors where clinical work is involved and where they will need to handle patients. Why? So there are a different set of standards. They don't understand that. I understand what those in the sector means, and for everyone he need to visit a doctor, and was the concern of the lay persons, and sometimes it could be one of those professional blind spot. These were the things we take for granted. Universities, they will not do something that would hurt their own reputation. For those people they hire, they could have vetted very thoroughly. They should be fine handling clinical work. However, from another point of view, why are there two different standards? Does that mean the university is more reliable than the HA? So that means the hospital authority is less reliable? So the hospital authority can also decide that these doctors cannot come with the appropriate qualifications, and then the conversation will just go on and never ends. And the chairman had mentioned that since this is already this limited registrations system is already in place. It's just that the hospital authority, for those without specialists, they don't have any doctors without specialist training, and yet the two universities count that. Let's not change what we have, as is fine as it is. So after this reform, why don't we consider those doctors with limited registration, if they're not able to achieve the minimum specialist requirement, we can just have them 1 year registration instead of converting all of them to 3 years. So the chairman also asked, what's the difference between 1 or 3 years? So does that mean the quality will be different? So a lot of people are worried that to attract more people if we extend for 3 years. By then, those who hire your university will be formed, because we trust on professional autonomy. However, it's very hard to me explain to my constituents that why some are allowed to deal with patients and handle clinical work, and yet they don't have specialist qualifications, and yet the hospital Authority just thinks it's non-compliant, yet it's allowed by 2 universities. Maybe I can try explain to that, because these 2 universities are can be trusted. So does that? I could be asked, does that mean the hospital authority is less trustworthy?
So changing from 1 year to 3 years. Maybe you just consider keeping it to 1 year when it comes to limited registration for these doctors, and there won't be any problem. Mr. Sun, thank you, Mr. Tan, for your very detailed analysis. Now, it's about really the vetting powers of the medical council, so it could be extended to 3 years. So the flexibility rests with the medical council. It doesn't mean that 3 years must always be granted. But if the medical council is not totally assured, then it could just grant 1 year. But if we make it so rigid in the law, is it necessary? Because under the current legislation, the medical council will only give 1 year at most. So that's why I'm saying, why change it? For non-local doctors with limited registration, they don't have the specialist qualifications considered so important by the hospital authority. If the hospital authority would not relax that requirement, why don't we just keep it to 1 year? I'm not starting anything new. So it's very difficult to explain that to people, and it's not really a major change. Dr. Zhang? Thank you. Let me try to give my view on this. There's double standards on the part of the medical council, on the hospital authority. No, there's just one set of standard as spelled out in the law. As an overseas qualification, overseas registration. If anything, the requirement is more stringent than that for local graduates, because it says adequate and full-time post-qualification clinical experience. So compared to a local graduate, the requirements are even higher, because there has to be post-qualifications relevant experience. So that's a higher requirement than for local students, graduates. So that's the standard. And then the hospital authority also asks for Cantonese and so on. But then that's not really specialist qualification. It's 3 years of qualification, because specialist qualification is 6 years, but it's not the case here. So why do they want to do that? Because they want someone to come and help. If it's a fresh graduate who comes to Hong Kong, he can't help. So that's the thinking behind it. So they want someone who is able to work at once. So that's why keep it to 1 year. But that's the reason for considered by the hospital authority. So it's not that the hospital authority has strong higher requirements than for universities. If you look at all the records, definitely the universities have higher requirements than the standard. But if you talk about 1 year and 3 years, okay, then we keep it to 1 year, the issue will go away, but the issue remains the same. The hospital authority still has these 3 criteria, and the universities don't. So the 1 year extension to 3 year is the same when it comes to the double standard you mentioned. So I don't think the university standards are lower than that of the hospital authority, but it's just that the hospital authority wants someone ready to work, and that's why they have this requirement. Universities, well, the universities will decide what they need. Sometimes they want someone with doctorate degree, some with specialist training. So if you look at the people hired by the universities, definitely they have far higher standards. Well, if you talk about it, I think we should cancel the arrangement for universities to bring in non-local doctors with limited registration who do not meet the standards of the hospital authority. And I'm not talking about that. I'm saying let sleeping dog lie. Just leave what is here. Well, the hospital authority has its operational reasons not to hire those people, but for the ordinance, we're talking about patient safety, and that's something we need to talk about. So for limited registration, already the requirements are higher than for local graduates. So you want me to explain to the public the universities bring in these people, you don't have to worry as far as their standards go, because they need to have relevant and adequate full-time post-qualification experience. That's in the law. But if it's the same person going to the hospital authority, would you let them in? No, but the hospital authority won't put in such an application in the first place, because the hospital authority has its own additional conditions to meet its own operational needs, and the universities have their own operational reasons, and they just put in applications for us to approve. But the hospital authority doesn't have enough doctors. If there are more doctors with limited registration, and if you think the standards could be guaranteed, then patients would be very happy. But because there are not enough doctors, no, for limited registration is something good because it offers flexibility. If you think that you need them this year, you can hire them. But next year, if you think you have enough doctors, then you don't need them. So this is a very good buffer for Hong Kong. But say in future, if we relax it to 3 years, does it mean many more people will come? No, definitely, because it costs to hire doctors. And can the hospital authority afford to hire a large number of doctors, or can universities afford to hire a large number of doctors? That's not going to happen. But Professor Lau, let me give you an example. Sometimes the universities may have different requirements than that of the hospital authority. So let me give you an example. Well, because they both need to do clinical work, please hear out my example. For everything that involves contact with doctors that requires temporary registration. So please be patient and listen to my example. Let's say there's a student who studies at Cambridge in the UK. And that's an interrelated degree that is after 3 years he stops, and then he gets a doctorate degree, and then 2 years later he graduates from medical school. And so the doctorate degree has to do with research. It's not to do with clinical. So for the doctorate degree, he does very well. And after he graduates, he's registered in the UK. He works for a year, and he hasn't yet taken the higher exams for specialist training. But because he's so good at research, the university wants to recruit him. Because he were talking about future stars. He's been doing well in all exams. He's star student, first class honors, everything. So, and he's proven his research talents. So the university wants him to continue with the research, which he does well. But to do research, he needs to take blood samples from patients. And if he does any clinical work, he needs to have a license to do it. But in that case, the university may hire the person, but the hospital authority will not hire that person because the university wants him to continue with his research work. But the hospital authority won't hire this person because this person can't help them. He can't do any clinical work. But then for university, one of the important tasks for university is research, and this person has proven his research talent, so he can stay there, and he can also take further training to become a doctor at the same time. So that's just an example. I just want to give you an example. Okay, I'm beginning to see that, but I want you to know what I've heard. Okay, the hospital authority hires doctors for one purpose, to treat patients, but when universities hire doctors, maybe they do research. But the research is about treating patients. And you think for these people, they are recruited, they can do both research and treat patients. So in theory, the hospital authority can hire the same people. They don't need them to do research, they can just treat patients. But it's a waste of research talents. But it's not about waste. It's just that the hospital authority is saying that they won't admit such people. I'm telling you, these are the people all universities want. First-class honor students, very good at research. And if you don't allow them to come to Hong Kong, they go somewhere else. So that's just an example. That's exactly this example that causes me to think, if these people are so good, they are totally qualified to do clinical work, how come the hospital authority doesn't hire them? Because the hospital authority can hire them not to do research or teaching. No, you don't get it, what it's like in the medical field. Research can take a lot of time, but the hospital authority needs people to do clinical work because they're mostly about clinical service. If people spend time on research, now that's the difference between universities and hospital authority. For hospital authority, it's mostly about clinical work, but universities, they do clinical work, they do research and teaching as well. So you mean for people who deal with patients all the time, the standards are up here, but for people who only deal with patients, sometimes the standards are as low as here. So then patients will be worried because we only get to deal with the doctors once. Yes, we want to attract talents. Yes, I see your point, but attracting talents by university is not the concern of patients. I'm saying that I let this doctor touch me in whatever way, and then I find because this university hires this person for other reasons, then he can touch me. But for the same person, if he goes to the hospital authority, he can't touch me, right? No, put it the other way. For doctors graduating from Hong Kong, after they go through internship, they will still touch patients. There are people to supervise them at a more senior level. You're talking about someone who touch you and they must be someone really bright, really qualified. Well, actually, there are a lot of doctors in the hospital authority when they touch you. They don't have the qualifications you have in mind. Now, all doctors are qualified, but they have different degree level of experience, first year, second year, third year, whatever. Before the specialist training is completed, that person remains a specialist doctor under training. And when he's under training, of course, he's under supervision, where is the case for hospital authority or universities. But then for hospital authority, they want 3 years experience, so they don't supervise this group, they supervise someone else. And that's why there are different qualification needs. Well, I don't think you can convince me, even if we go on. Well, you're someone hard to convince. We've been talking about this many times over. I see your point. But then even if they're good doctors, the hospital authority may not have the resources to hire the best doctors all around the world to come and treat patients in Hong Kong. That's unfortunate. And even if they have the money, they may not be able to hire these people. So your wish may be hard to realize. But of course, there are others who want to do research. They don't want to treat people so much, but there are others who just want to treat people, but then they may not have the capabilities to do research, or they may not have the interest. Can I ask the government, if we keep it 1 year, we don't touch it, that's fine. For the others, you can change it to 3 years. What about that? I think that is in conflict with what you said. I'm in support of 3 years. So you're saying that you want the hospital authority to have more doctors, you want them to hire better doctors. Now, even for doctors who will go to work for the hospital authority, just 1 year. Let's say there is a department store in the United States who will hire you for as the CEO, but only for 1 year. Would you move your whole family there? Well, in that case, open it all to open it up all for 3 years. No. The whole the bill is about giving the medical council the flexibility. If they have doubt, they can just grant 1 year. But there's the flexibility. For some, they can be granted 3 years, because some may say, I'll only come if there are 3 years, not 2 years, not 1 year. So there's more flexibility for them to attract more talents. Now, I'm all for that. If you're all for that, there's no reason why you would say, well, let's not touch the 1 year, let's leave it. Mr. Chairman, what I can accept is that the hospital authority hires the same people. If you think there's not a problem and there are not enough doctors in Hong Kong, then the hospital authority can hire the same people. Now, but the government gives some money to hospital authorities. It's up to them who they hire. But then the medical council tells us here that they have high standards. They will never let in such people. That they've told me that's here in this room. And that's what's really, putting me in this position. That means they can't read the requirements. How come then in universities they are fine? No, the hospital authority wants these people to be able to serve on the first day of duty. But for first year doctors, they need time to gain experience. The hospital authority doesn't want to use public money to train people like that. They want someone who can help at once. Now, if you give, sometimes they may apply for 3 years, we may just give them just 1 year. Let's say is a fresh graduate, is a PhD, maybe we just give them 1 year because he doesn't have the experience. In that case, the universities should undertake that for these people. They won't be allowed to do any clinical work in the first year. But some have much experience, others have no experience. It's up to it really depends on the individual. But we're just giving the medical council to give the power. This year, perhaps they can grant 1 year. Maybe next time round they can grant 3 years. So we're just giving the flexibility to the medical council. Next, Mr. Xiu Kachun, speaking for the first time. Thank you. I would like to talk about election. I'm changing subject. 3 representatives from patients' organizations, I welcome that. The Department of Health will devise a electoral system for them to elect the patients' representatives, and I welcome that too. But my question is not to do with patients. My problem is not with the patients' organizations, but rather the Hong Kong Academy of Medicine. Now, for HKAM's representative, instead of being appointed, they will be elected in accordance with the rules and procedures of the Hong Kong AM. So what do you mean by the rules and procedures of the Hong Kong Academy of Medicine? What are they? So that's my question. Mr. Sun? Well, the law puts it this way because, first of all, the Hong Kong Academy of Medicine is a statutory body and it has its own professional autonomy. It's about the training of specialists, and they decide on the criteria. And also under the Hong Kong AM, there are various specialist schools. So if the 2 representatives from HKAM are elected, then the way it's to be done should be decided by the Hong Kong AM. That's the whole spirit. We don't believe we need to spell it out clearly in the law what the Hong Kong AM must do, because we have to consider the unique nature of the Hong Kong AM. But for these 2 representatives of the Hong Kong Academy of Medicine, it's up to them to decide how they will elect those 2. Yes, I get that, but there are criticisms for different specialist schools. They have different number of fellows. Yes, true. Some may have just less than 200. In other, they have over 1,600 fellows in a college. So is it the case that you say you respect Hong Kong AM and do you disregard all these differences? No, I don't get your point. So different colleges have different number of fellows. That's not a number caused by the government. It's for doctors to decide which specialty they want to go into. And that's why for a specialty, they have different number of members, and that's all. So even if the number is uneven, but it's not slanted in a way. Let's say for medicine, there are 1,600 fellows, and social medicine, less than 200 fellows. So in their own, if we leave it to them, then it's possible that they will just elect all medicine fellows because they have there are more of them. Now, I don't have any position on that, but a year before you joined LegCo, already we met with different stakeholders. They came to give their views. The Hong Kong Academy of Medicine has a different view than that of doctors. Doctors believe that they should be by 1 person, 1 vote to elect the 2 representatives. In the past, they nominate 2 persons, and then the CE will appoint that. But then the CE said that there's no need for me to appoint them. They just elect their own representatives. That's good enough. So that's why there are doctors groups which say that there should be election by the Hong Kong AM. But then there are Hong Kong AM members who exactly gave your views that in some colleges there are just 200, others 1,600. So we leave it to us to elect our representatives. Then maybe for people of different specialties, they may not have equal chance to sit on the medical council, but it's 1 person, 1 vote. Well, then, like you say, there are 1,600 people. Maybe they will all vote for their own medicine specialists. So that's why different doctors' groups actually have different views on how the two representatives of the Hong Kong AM should be nominated or elected.
Apart from respecting their autonomy, how are those two members generated? The government has been allowing the Academy of Medicine to decide. So how do they actually decide? It's up to HKAM. Their members are chosen by their fellows. So the government has said that they do not want to stipulate how Hong Kong AM chooses its members. So at the end, the Hong Kong AM can use whatever way they want to generate its members. The spirit is to respect the unique structure of HKAM. So it would be ideal for their fellows to decide the members. As the chairman said, when we scrutinized the 2016 bill, we had representatives from the Academy of Medicine. They said the Academy of Medicine adopts a federal-style hierarchy, much like the United States government. And the colleges are like the states of the U.S. and the colleges are of different sizes. For example, we need a lot more doctors in medicine than social medicine or social health care. So that is just one of their unique characteristics. So when electing the Hong Kong AM members, we must respect its uniqueness. And that's why we feel that we should leave the matter to HKAM, because their colleges and their fellows have different views, and HKAM is a statutory body and its operation is already bounded by laws. So nonetheless, the HKAM must reach a consensus within itself in generating the members. As to how we find it ideal to allow HKAM to decide how it decides its members, Dr. Chung has something to say as well. This is actually not new. In our current system, there are 7 MCHA members are elected by MA, and for the 7 members elected by MA, on how these members are elected, the medical association would decide for themselves. We are now just applying the same method to the Academy of Medicine. Whether it's a good practice is up for debate. And the different councils or associations might have different sizes. There are 7 directly elected members from the MCHK. Hong Kong MA claims to have 9,000 members. So apparently they have an advantage, but we still allow the direct elections to happen. Of 14,000 doctors, 9,000 are MA members. Some of them are not affiliated and still they are elected. In lack of a better option, this is already the best option. For HKMA, of the 14 members, 7 are nominated by members and 7 are elected among doctors who are members. So both methods are being used. So the government does not intend to lean towards any one of them. Does the same logic apply to the Consumer Council representative? Apparently, the member is elected, and that person will become a lay member. So would that member from the Consumer Council be considered elected or appointed? The Consumer Council member is elected, but the government would not make an appointment. The nominated member from the Consumer Council is not appointed, but that person is also not purely elected. It's hard to categorize. Is there universal suffrage for the Consumer Council members? Well, that would be a very high price to pay. We see there's a gray area in which a member is neither elected or appointed. We talked about the appointment of lay members. So they are all appointed by the chief executive, including the Hong Kong Academy of Medicine, Medical Council, etc. So the 4 new lay members, well, 3 of them are elected and by patient associations and the Consumer Council. The rest are elected within patient organizations, and there is no appointment by the chief executive. So the 2 current places at HAM are appointed, and the chief executive has said that he will no longer make appointments. So this has struck a balance. Any follow-up questions? Next, Dr. Pierre Chen. 4th round. While we are talking about elections at HAM, in our discussions in 2016 and 17, when we look at the paper CB brackets 2009A/16 to 17 brackets 02 page 11. Last time I asked about the Academy of Medicine, and since Mr. Xiu is talking about it, I'd like to follow up. We talked about the federal system in the United States, and we talked about taking care of colleges of different sizes. So I looked at the past annual reports of the Academy of Medicine to look at the composition of the 26 council members. And if there are 15 votes for the 15 colleges, if we have 1 person, 1 vote, it would be fairer. If we have 1 vote for each college, it would be fairer, so that the bigger colleges would not have an advantage over smaller ones. But when I looked at the facts in the HAM Council, there are 15 plus 11 members, 15 members from each of the 15 colleges, and of those 15 members, we saw that smaller colleges such as the social medicine college, they had 2 or even 3 votes. So the situation persisted for a number of years. For the Accidents and Emergency, or College of Emergency Medicine, they had a few votes as well. So they had even more votes than the bigger colleges. So that's what I observed from the composition of the membership. So this is actually against the principle of fairness you suggested. So when it comes to an election, smaller colleges had even more votes. So this is just a bit of background for reference. I'm still consolidating the information. And in the same paper, I'd like to talk about page 3. It was a letter from the government. It was a letter from Ms. Lau, and the Food and Health Bureau offered a reply on the government's response. And last time, and it says, I said certain things that day, and members requested CUHK to provide its guidelines for governing the provision of medical services to private patients. And some members asked why certain doctors with limited registration could engage in private practice. And in the letter, it said CUHK could not provide the guidelines. I realized that Hong Kong U has a set of such guidelines in place. After the meeting, or even now, can you tell us whether such guidelines are in place? If we hire locally registered doctors in universities, there should be stipulation on the amount of time spent in private practice and the financial arrangements, etc. All these should be very clear. Since a past blunder, there are clear guidelines for university professors already, but the letter said the guidelines could not be provided. Was it due to a lack of time, or is there a lack of such guidelines? Last time we found out that doctors with limited registration can touch the patients or even engage in private practice, but we had no details. Mr. Sun, Chairman, thank you very much for the question. As we said in our reply, in the last meeting, members asked the CUHK representatives to offer the guidelines for professors engaging in private practice. So we had asked CUHK, and in response they said they could not provide the guidelines. So we can only relay this message. If members feel that we have to ask CUHK and Hong Kong U again, we are happy to do so. I think that would be ideal. You can ask whether they will offer the guidelines. Are they unable to offer the guidelines, or they have no such guidelines to begin with? And if they have no guidelines, can they provide records of the time spent by professors engaging in private practice? If they have no such figures, then at least we would know. If they have the information and they need time to gather them, they can tell us how much time they actually need. By saying they would not disclose the guidelines, it might mean that they have no such guidelines, or they have no guidelines for doctors with limited registration, or no guidelines for all doctors. There could be a lot of possibilities. I know that HKU has such guidelines since an earlier blunder. we know that doctors with limited registration can help Hong Kong people who would need public healthcare services, and we understand that they might engage in private services as well. So we would like to know whether there are guidelines. Would there be any restraints on the time slot or the amounts of time spent, saying that they would not disclose the guidelines should not be taken as an answer. Is there any differentiation between doctors with limited and full registration in Hong Kong U and CUHK? We will follow up on this in our paper and my opening remarks. If you are on limited registration and if you work in engage in private practice, the amount of time cannot exceed 10%. So we will ask the two universities to give more. The actual figure, the actual percentage might be less than 10%. For the universities or university professors, is there any differentiation between the requirements for doctors with limited and full registration? Is it still capped at 10%? To follow up on what Mr. Shields said, some small colleges from the Academy of Medicine had 3 votes. Do you have any comment on that? The composition, I wonder if their composition has anything to do with our bill. Well, if the smaller colleges actually had more votes, perhaps we would just revert to one member, one college, one vote. So, do you actually want to pursue this? If so, you can move CSAs. If you like, you can revert to one college, one vote. Thank you very much for the elaboration. On page 11 of our paper, under the laws, there is stipulation on how the 26 members are elected for the HAM Council. For the 15 colleges, the heads would be members, and there would be 5 directly elected members. And in the same, no more than 1 member can be generated by each college, and the other 5 and 5 more would be nominated by members. So the number of votes have not been stipulated. So he looked at the reality. And he's telling you that the reality is not the case. So apparently there's no direct correlation. So unless you would amend that, or if you are going to amend the composition of the 26 members, this is not within the ambit of this bill. As the chairman and Mr. Shiu said, we will allow the Academy of Medicine to choose its members. And there's an imbalance in the number of votes within their colleges. This is not. This does not align with your principle of fairness for different members and colleges. So in reality, I saw that some colleges had as much as 3 votes.
Under the existing provisions, you could have offered CBAs, and now that there are only 15 that so dean of the colleges, why didn't you elect 2 representatives? In this way, If you feel that 15 is fair, just responding to the question, Mr. Hsu, that each college will have one vote, regardless of big or small, especially colleges like the Federation, about 50 states and the Senate, regardless of the population, each state gets 2 votes. You would consider persuading your colleague that and to restrict it to 15 members instead of the 26. That I understand. So I would provide some information. I heard at this meeting that each state having 1 vote. And the council of the HKAM is not a federation system because some state have more votes, so to speak. More than one. Of course, no one has spoken like that. Just recapping the HKAM words. So some of the members have slight differences in terms of what they said, but that's okay. However, this is not something we should devote too much time to discuss today. You feel, or your colleague LegCo support on the your colleagues returning to 15 seats. I'm fine with that. I might agree with your amendment if I feel that I'm giving a fair chance for each colleges or let them discuss it. Is fine with that. I agreed with that. The doctors would have exchanges. We're going to foreign countries to learn new stuff, so therefore we need to allow overseas doctors come to Hong Kong, and the kind of reciprocal exchanges that I heard that would help that the overseas doctors coming to Hong Kong should be of high caliber and world famous. So going on to the page 4 of the reply, I would like to know that for the One Belt and Road Initiative countries, page 4, Bahrain, Nepal, and Oman. So what's so special about this doctors coming from those countries that we actually need them? And also I want to know that since there is a reciprocal exchange of any doctors training in Bahrain or Nepal or Oman, so what's so good, what's kind of cutting edge technology that we need to fly doctors to there? Because I haven't heard of such before. Usually doctors go to Japan or the US or Europe or UK for training. Now, well, some of the doctors would go to the mainland as well. For what I know is that maybe Mr. Hsu can answer that. It's probably not for a one-for-one reciprocal agreement. Probably, well, maybe Mr. Sun or Professor Lau can answer him. I have no idea why these 2 universities choosing countries from these countries. I believe that the university has a reason for choosing these doctors, and Professor Lau is always an important figure in the CUHK. He might not be as well. But why do we need to have doctors from Nepal? I'm sure that has reasons. I think under such rigorous mechanism, the unis would have a reason. Can Professor Lau answer that? I can't answer that on behalf of the CUHK. From what I know, that once Nepal had a neurosurgeon coming to CUHK for training. Upon returning to Nepal, had become the Minister for Health. So sometimes the work done in universities may not be for a one-for-one exchange. Maybe if we would like to train talent from other countries so that they can serve in their home countries. So there could be one possible scenario. Next, we have Mr. Tam Ho second round. Okay, put it this way. Mr. Tam has second round, followed by Ms. Dr. K.K. Kwok for 4th round. And Mr. Yip Kin Yoon is not here, so let's draw the line here. So after you finish speaking, we shall adjourn the meeting. Mr. Tam, please. Just going to this PowerPoint. Which page is that? On procedural. Oh, we may not probably need to refer to the slides. And under your proposal, you're going to have for the pool assessors could be anywhere from 20 to 140. And within this pool, let's say 16 to 80 are doctors, about 12 to 60 are lay members. I'm fine with that. And this pool of assessors and would be appointed to the PICs and the inquiry panels. So and the members of the PIC and the inquiry panel are drawn from the pool of assessors. So would that say would it restrict this certain assessor serving only at PIC or only at inquiry panel, etc.? No, Chairman, no. There's no restriction. For the same pool of assessors, they could either serve in the PIC and the inquiry panels. However, there are also stringent conflict interest arrangements. If you serve in the PIC, you cannot serve on the same case inquiry panel. So for the same case, if an assessor already served on the PIC, and when they get to the inquiry stage, he could not take part. So for the same case only. So for here, I could not found it on this PowerPoint. However, would that be included, made it clear in the legislation? Mr. Fang, please. The existing legislation has such arrangement. However, we will spell out clearly. So this expansion of the assessment pool would not allow this scenario to happen. Another question for the pool of assessors, is there any, what is the term appointments so that you have 8 organizations nominating 2 to 10 and the following organizations are free to nominate 2 to 10 persons? So what's the effective period for nominations? 3 years, like we mentioned. 3 year each term, and they could go on indefinitely. Would that lead to the scenario in which there's one batch and in 3 years, well, in principle, they could be completely replaced because each organization send their own representatives. I understand this a 3 year term. You make explicit that 1st of January 2018. So what you're worried that once this is in place, let's say we appoint 300 people, and after 3 years, on September 23rd, 3 years ago, all those 300 assessors could be replaced by new people. I'm worried about there will be some chaos. We should have a mechanism in place. The existing medical council members, the election would hold for all members, so it's only there are 3 vacancies up for re-election. So the same arrangement will work for assessor because there will be 4 additional assessors, and would differ from the 7 plus 7. Well, the Department of Health and the university's appointment at the same time. Let's not be confused. Maybe I'm not made it clear enough. So the members and the assessors. So we have a number of the assessors for the nominations. The election could be done in stages. What we don't want to see, like Mr. Stanley said, is a theoretical possibility. So it's not something we all want to see. But the current legislation, after you've been amended, if there are any safeguards to ensure what Mr. Tad mentioned will not come true, we talk about a maximum of 3 years. However, in practice, they would not ask him to fill up all the vacancies, maybe 2 nominations, 2, and then 3 nominations at a later stage. If we don't make it clear in the ordinance, let's say for the 3rd or second reading, maybe the Secretary explain clearly how do we deal with this so that they would prevent this kind of scenario, because it's just simply harmful to the entire structure. The chairman have been quite wise. And we set it at a certain day because this assessor system is a new thing, and so I'm worried that you gave them a date and you start nominating from when and after. So it's all fine for now. And after 3 years, would it let you a replacement? Let's say all 100 people all be completely replaced in one go. So even if we replace 100 in one go, it will be still quite a shock. So sometimes we have the replacing members on 1/3 and 1/3 increments. In the second year, we replace another 1/3. So to prevent this kind of situation in which all the existing members would be gone, or maybe the second or third reading, maybe the government need to think about how to cater this instead of the legislation. It should only happen in the first year of implementation, and maybe have to every 3 years the next person. Dr. Kiki Kwok, fourth round. So after you've spoken, the meeting will be adjourned. Okay, so I have quite some time, 10 minutes at most. Some of the figures, I hope that Mr. Soon can provide them. And on the number of limited registration doctors employed by universities. So I concurred. As for the more senior academics, like Dr. Professor Lau, so we do treasure the teaching staff. We're more concerned about a more junior and those in training. Thus, we hope the government would act as a gatekeeper, because the medical council thinks that as confined by its scope and the law couldn't do much. I hope that Mr. Soon can think a bit harder. For those for the referred by the hospital authority, I have no problem with that. I think they have no safeguards to protect the public. However, on the private university, I hope that the government could give it some thought. I'll give you some time for that. And on the part of Mr. Fong, right, and on the PIC and the inquiry panel, and for the PIC, currently there will be 4 doctors and 3 persons, and in the inquiry will be 3 doctors and 2 lay persons. Currently, we do not. The current medical council for any inquiries, they will not restrict the number of members. Suppose the membership will be set in stone, or depend on some cases in which get to 32 people, about more members would like to take part in the inquiry, or you set an upper limit, or you fix the size of the panels at a certain size. For example, how do you make this PIC or inquiry panels and more representative? Let's say 4+3 or 3+2. So if we increase the members in proportion, that decision would be able to more represent of the views of the medical council. That would be important. That is the minimum demand. The second question had to do with the legal advisor. I know that is a ceiling of $280,000 per month. This is not no small sum. In the last, the former legal advisor had annual pay of more than $4 million. And at last session, they mentioned that why did not try to hire a full-time legal advisor to say on behalf of medical council would be a better use of public money. We don't mind hiring 1, even 2 or 3 legal advisors, depending on the need and on the However, from the public finance perspective, 0.28 million per month is about over 3 million a year. And since it's a part-time only, it would take outside work as well. So, and also, and the first case of the medical council is still the advisor sent from the Department of Justice, and we trust that there's no conflict of interest, and able to work dedicatedly for the medical council. Now that we have a part-time legal advisor, and his pay is quite much better than a lot of full-time lawyers at the Department of Justice. Why is this happening? Why don't we hire 2 or 3 full-time legal advisor? Isn't it better to safeguard the work of the medical council and as a more optimal use of public funds? So you have a part-time work for over $3 million a year. I will not extend it for more than a minute. So if we keep on dragging on, I wouldn't let him reply that you could only save the question next time. You've been really helpful, so I will let him answer that. You can keep asking, and you wouldn't let him answer it. Mr. Sun, I'll let Mr. Fang answer the first question on the quorum for PIC, or maybe Mr. Lai could also elaborate on that as well. Thank you, Chairman. The proposal would suggest having a 5-member group. Maybe you have a lot of 5-member group. So it's set at 5, the existing practice. That would something to be appropriate. Because a lot of restaurant organizations even have 3. So we think that 5 is this appropriate figure. So we have more or less. If we have too much members, it's hard to form a number of PICs. So in view of other considerations, we think 5 is appropriate. Second question. On the question of legal advisors, Ms. Lai, currently we're engaged a part-time legal advisor, over 3 million. So it's a pretty nice part-time job. It's actually the maximum. However, we will not claim that full amount. Is actually based on actual work. As for whether hiring full-time legal advisor, it depends on the circumstances. Currently, our legal advisor did not claim the full hours as a full-time legal advisor. So we shall wrap up discussion. There's no other business. I declare the meeting adjourned.